Division bench, item 1 to 13 to be spoken to.
Yesterday,
Ah.
those effort was done.
Ah.
That's enough.
Because my courtmaster said that he wanted to interact, so therefore we got it listed.
Regarding the translation part, Your Lordship, because I have already given it to Your Lordship, my Lord, original and English translations were already provided to the court, trial court below, my Lord. This was discussed, my Lord. The trial court has discussed this at para 41, page 967 of the judgment, number 1. As there were, my Lord, as there were 2,781 emails, the prosecution only translated the relevant that were important for the case, my Lord. Now, the defense side, in a trial court below, my Lord, the defense side took no objection of the emails. And that will reflect, my Lord, in the judgment at para 42 and 43, para 42 and 43, at page 968 of the judgment. Now, whatever happened in the trial court, my Lord, that if they wanted something more, etc., they could have raised their objection, my Lord. No, that part was over. Now, interestingly, in the High Court, Your Lordship, in the High Court, Your Lordship, paper book, part 1, volume 5, at page 1093, there is an order of the court, my Lord. High Court, my Lord. Part 1, volume 5, 1093. My Lord, there, when a matter came before the High Court, my Lord, the defense side, they accepted the order, was they accepted the earlier translation. And regarding 58 emails, my Lord, 58 emails, they said they undertook that they will translate the same and place it before the court. The matter ends there, my Lord. That part, it did not come before Your Lordship, my Lord. Oh, what are they? No, no. That could have been. They don't. But I've got an order, my lord, that's 27/8/2018. SPS 1093, my lord. Mr. So-and-so and B. Prasad, learned counsel for the appellant. So-and-so, learned counsel, learned special public prosecutor, and learned counsel for the appellant have submitted a list of 58 documents stated to be emails which are in Manipuri dialect. It is stated at the bar that these documents are required to be translated into English for preparation of paper book. They further submit that translated version of the rest of the documents in Manipuri dialect is already available on the record in LCR. As such, retranslation of the same is not required, as they would be relying only on the translated version which are already available on record. Learned counsel for the appellant submit that they would themselves translate 58 documents in English and submit the same to the registry on or before 12th October 2018. They are also permitted to. In the meantime, registrar proceed so and so. If your lordship want to see, at page 1093. So my submission, my lord, regarding this emails, exhibit, etc., my lord, whatever was available before the trial court and whatever that has been done, that ends there. Now, before this appellate court, my lord, is only a question of appreciation. Whatever has been done, whether how your lordship will appreciate that, we have already argued the matter, my lord. That only remains. It's not a question of rehearing the same or putting something new before you, because that has to come from the trial court and then here, not before the trial court. And they had a scope in 2018, my lord. The court has given it, okay, 58 emails, which you want, rest of the, because that was not a part of the judgment there. These 58 emails, they say that we want to 50. That my humble submission, the matter regarding this. Otherwise, your lordship will have to open a case and rehear the whole matter.
Yes, but
My lord, the translations are made for the convenience of the court, my lord. My lord, in this present case, the prosecution chose not to exhibit the translated copies, my lord. If your lordship may peruse the original 115 series. The original email in Manipuri dialect is there, which has been exhibited.
like once,
The first one.
this
Right.
one.
Right. The original email in Manipuri dialect has been exhibited, my lord. Thereafter, the translation copy is there, which has not been exhibited. So there was a confusion when the paper books were given to us. It was handwritten that is a so and so exhibit. Now, the issue that we have raised that whether the learned trial judge was acquainted with Manipuri dialect. Because he cannot go beyond a document which has not been exhibited. He has to confine himself within that.
You have no faith on Google Translator.
Your lordship can see it. Even the Google will not translate it.
It will not.
No.
How you are saying it so confidently?
Your lordship on the last occasion had seen it in the open court itself.
You have seen it.
Your lordship has seen it.
I
Check.
have seen it.
My lord. Because it is in English Roman dialect, not in their local language. They do not have their own dialect.
Okay.
And so far as the missing documents which were recorded, my lord, we have seen those are available, are in Manipuri language only. There is no translation. So those were not made a part of the paper book. And to that effect, there is an office note dated 1/9/2023, madam. One nine 2023.
What did you say about those 58 documents?
58 documents, initially we had said that it may be relied on. However, later on, we did not submit it. The appellant did not submit it because whichever is available, we said it was before the trial court, so it should be before the high court also, not the other ones. And accordingly, the paper books were prepared with the available translated copies. And so far as placing that matter before the learned trial judge in the judgment, in paragraph 43, they stated that on perusal of the files containing exhibit 115 series, it was seen that the original communication in Manipuri language was followed by the respective English translation wherever necessary. It was therefore difficult to accept the defense proposition that the translated versions of the emails were not part of the record. So we had made an defense that those were not part of the record because they were not exhibited and therefore those should not be relied on. So it is recorded. Paragraph 43, page 968 of the judgment. And very few exhibits which were missing in the paper book. We have seen that while numbering it, the person who had numbered the exhibits, he missed those. He missed those numbers. So accordingly, those exhibits are not there. Very few. Otherwise, all others are there.
Please
My lord.
explain this.
My lord, we had stated that some documents are not available in the paper book. So we checked the records yesterday. We found some papers, some exhibits, which were in Manipuri language, and therefore they were not made a part of the paper book. Some exhibits were missing because they were missing in the original itself. If it is page number 1, 2, and 3, and he had marked exhibit 1, 2 here, he marked exhibit 4 here. He himself missed exhibit 3, the person who had numbered it. So very few, otherwise not relevant. And this was in regard to where more than 50 or 60 pages were there. Somewhere page 49 was missing, exhibit so and so oblique 49 page number was missing. Otherwise, this much I have to submit.
Malad, what I would submit, Malad, whether some of the missing documents or non-translation of any of the documents, whether it goes to the root of the matter, that your lordship will consider and try to. Because there were so much of email. If the prosecutor brought a case, otherwise, but if few the emails, matter, somewhere something, because out of 2000 so and so documents matter. If it is, that's the root of the matter, your lordship will assume, because it is not a rehearing of the whole matter, but I'm just putting it before your lordship.
You see, just as a student of law, I'm trying to ask a question. A document is marked as exhibit. A document is marked as exhibit, it is recorded in the order sheet or in the evidence that particular exhibit is exhibit A. But this exhibit A was not marked in the document and not signed by the court. In the oral evidence,
Quite true, madam.
exhibit A is recorded,
Madam,
but exhibit
I
A
understand.
is not marked in the document. What is the consequences of that?
Madam,
So far I understand, this document must be sent back to the trial
Trial court.
court and
yes,
those missing out
madam,
has to be exhibited.
madam. That is, I have found a judgment, my lord. It happened that way, my lord. Because marking, etc., everything done, but somehow.
That's okay. Because it is only that trial judge who will be knowing what has happened actually. So although he may have retired or might have been transferred, the practice being followed here is that it has to be sent to the same same presiding
Same
officer,
presiding officer.
notwithstanding that he is superannuated, but that marking would be done, it goes back to the trial court will endorse the signature of the exhibited document by the then presiding officer, and then the records are regularized. That is what I can understand.
Madam.
But I can't be very sure.
I found a judgment of that sort, madam. I do not know. I just recollect, madam, that
My esteemed brother, remember the judgment. We have found that judgment.
Wherever and everywhere. It will not have particular well, but that's what I want to say. The good teams here like this.
For a moment, if your lordship will look into that Guwahati High Court criminal rules and orders, matter. Criminal rules and orders. It is with the court. The rules regarding exhibits begins with rule number 17, my lord. The relevant would be 19 and 20, my lord.
Rule number
19 and 20.
1920, what?
Yes, sir. Criminal rules and orders.
Can we go ahead?
Criminal rules and orders. Criminal, Guwahati High Court criminal rules. Rule 20, my lord. If any of the exhibits contains many papers, each page has to be marked as exhibit. Now, exhibit 115 continues up to around 900 pages. Not even a single translated copy which is attached with each of them have been exhibited. It has not been marked. Had it been a case that the seal was marked, somehow the judge didn't mark it, then it would have been a different case. Your lordship would have remanded it back for correction. But here, purposely, it was not exhibited by the prosecution. It was available there. Even 161 statements are also available. But if it is not exhibited while cross-examining, that cannot be looked into. That is rule 19, my lord. Anything brought to the notice of the witness has to be exhibited, immediately marked. And Rule 20 says that each page has to be marked as exhibit. And so far as proof is concerned, the documents have not been proved. The contents of the documents have not been proved.
All sides are represented. The inspection of documents, inspection of the original exhibits which have been received from the trial court have been inspected. And in this regard, submissions have been made by the learned counsel for the applicants, as well as the learned senior counsel for the
And I,
respondent number 2. Arguments are concluded, judgment is out.
Yes, Lordship. Much obliged, Lordship.
My pleasure. Lordship, I beg to mention item number 11 of today's list. Lordship, I have received a copy of the affidavit in opposition today. Lordship, I pray for 2 weeks' time to file a reply. Lordship.
He has received copy of the affidavit in opposition today, and he prays for and granted 2 weeks time to obtain instructions and to file reply if required.
Lordship. Obliged, Lordship.
This up to 2 weeks.
May I please, Your Lordship, I beg to mention item number 12 as the senior counsel is out of station.
Well.
12.
You have a petition.
Petitions.
Okay. All sides are represented on the prayer made by legal counsel for the petitioner. The petition is adjourned today. Let's start 2 weeks.
May I please, Your Lordship, I beg to mention item number 5. My senior, Mr. Espidas, due to some personal difficulties, he could not come. My lord, may this case be fixed on any day for the next week?
It goes after 2 weeks, so you're not fixing a date right now. Also, this is motion matter. This one 24/4/2024 as prayed for by the counsel for the petitioner.
Item 1 for motion. May it please, Your Lordship. Lordship, matter is pertaining to Lordship compensation of appointment, Lordship. Lordship, during pendency of this petition, Lordship, the DLC has already recommended my name to SLC, Lordship.
Upon instructions, Mr. J.
Jai Hati Moria.
Hadmari, learned counsel for the petitioner, submits that during the pendency of this writ petition, the name of the petitioner has been for appointment on compassionate ground by the DLC. According to his instructions not to press this matter. This.
I am
PD,
looking for respondent number 6.
Government and then additional senior government advocate appears for respondent number 2.
Ashok, I'm appearing for the elementary education department, A Fukan,
Mr. A. Fukan,
for 1, 2,
1, 2.
learned standing.
1 and 6, I am appearing, Lordship. 1 and 6, I am. 2, 2, 3, 4,
4, my lord, and
7, 8.
7 and 8, I'm appearing.
2, 3, 4, 7, and 8. Matter stands closed on having not been best.
Obliged, Lordship.
Deeply.
Item 2.
May I please your lordship? Lordship, in this case, I am representing myself. Lordship, I applied for a passport. Lordship, it started in the year 2017. Where they closed my file without any explanation. And that time I withdrew my application with the liberty to file afresh, which they allowed. And this time when I filed in 2020.
Take it after some time, you, since you are petitioner in person, you open up your band and come in.
Pardon, sir?
You are petitioner in person,
Yes,
you'll have to
remove my ban.
remove your band and then come
Okay.
after some time.
Item 3,
Yeah, please, your worship. This is regarding non-payment of contract or
Just non-payment of contractors bill.
lordship.
Non-payment of contractors bill. Notice. Will accept notice. Will accept notice for respondents.
Agriculture. Agriculture.
Ms. Das, you are accepting notice for all the respondents?
Agriculture Department, item number 3. Agriculture Department is there, man.
Agriculture is Mr.
Agriculture,
Chaudhary.
Bikram Chaudhary,
Bikram
yes, yes, ma'am. He was here, my lord.
Extra copies. Pendency shall not be allowed to examine the claim of the petitioner to release payment if found due.
Lordship, obliged.
item 4,
Yes, Mr. Chakravarti.
Well, I was awarded a contract at the time of inception of the COVID period, my lord. Then the awarded transportation I could not do due to that situation, my lord.
Can issue notice.
Yes, my lord.
Mr. B. Chakravarti, counsel for the petitioner. Deduction of a sum of rupees 45,99,718 from the bills of the petitioner is held in this requisition filed under Article 226 of the Constitution of India. B.K. Singh, that counsel for the respondent accepts notice on behalf of all the respondents.
All the respondents.
Requisite extra copies, be furnished within 2 days. Next, pendency of the petition shall not be a bar for the respondent and parties to examine the claim of the petitioner for
There is no
the
interim
reversal of the deduction. You just examine it. Pendency shall not be a bar. Notice made within 4 weeks, next not performance.
Obliged.
item 6,
Outstanding bill. Mr. L. Mohan. Outstanding.
For all,
Bill for hiring of vehicle.
I'm for all, my lord.
Okay. You guys, the government advocate accepts notice for all the respondents, extra parties. Pendency shall not be bar.
item 7,
7 of it.
Same.
Same.
Item 8,
Yes.
This is a petition for grant of license of IMFL of shop. What has happened here, Lordship, the petitioner's father, Lordship, approached this Honorable High Court. The Lordship will find Annexure 1, page number 13. By way of filing a writ petition, Lordship, and it was directed that his representation be considered. Thereafter, Lordship, he has approached the Deputy Commissioner, and Deputy Commissioner wrote a letter
What
to.
what do you want? What is your prayer?
My prayer is now for disposal of my representation, Lordship. My representation, Lordship, will
No,
find,
no. What was your original claim?
my claim was that the license should be, because that shop is lying vacant. That area is also lying vacant and there is no IMFL shop, Lordship. So the license may be granted to me. That is my, because earlier it was, my father has, there was order.
Is this IMFL license
Yes, sir. Yes, sir.
is transferable otherwise?
No, no, no.
So it has to be a
License is
fresh
not
license.
Fresh license.
Yes.
Well, in this matter is not conducting by Mr. P.N. Goswami, my lord. He have to take his father to medical treatment from Delhi, my lord. Can it be up next week, my lord?
Next week.
Yes, ma'am.
But a date be fixed then, Lordship, in that case. As per their convenience.
Next Friday? Or Monday?
Monday.
Monday, Lordship, there is some difficulty. Can it be on Wednesday, Lordship?
First of May.
First of May.
Okay. What is it represented?
First or second?
Prayer
as
for
your
adjournment is
preference.
made on behalf of
Second for the.
uh,
Can it be on
Goswami,
second May, Lord?
Advocate General for the state. So prayer is allowed. List on 1/5/20.
Can it be on second, Lordship?
Second is a hearing day. You are reserving those days.
Third May, Lordship?
Third, okay. 3 5/2024.
Developed. Right.
item 9,
Just a moment. Just a moment.
অলপ সময় হেৰি দাস
Uh,
My lord.
as notice of motion. Was issued on 19/2/2021. The counsel for the respondent shall be ready with their instructions.
Yes, ma'am.
nine,
Yes, you filed an application. for substitution.
Lordship, I have filed substitution. It was allowed also, but because I was admitted for hospital, I could not submit the amendment cost that will result. Yeah, today itself I will submit it.
Okay. Mr. L. Mohan, learned counsel for the petitioner. Has submitted that although the interlocutory application for substitution was allowed, but as he was hospitalized, he could not file the amended cost title on. First off, said explanation is accepted. Learned counsel for the petitioner is granted 2 days time to file amended cost title. Before the EOJ.
civil rule pending,
Civil rule pending section. On receipt of the same, the necessary corrections will be done. First one. List after 2 weeks. Passing appropriate orders. Already.
item 14 for item 14,
Yes.
And here, my lord, I am appearing for respondent one.
Yes.
But if the case, my lord, arising out of an order passed by this honorable court, the granting of rupees 2 lakhs, arising out of motor accident, my lord, ex gratia. Now, my lord, the department, revenue department has communicated to the deputy commissioner Dhubri for, my lord, sending the proposal. Because the formal proposal will have to come, my lord, from the DC.
File an affidavit because contempt matters, it will be very difficult to accept.
No, my lord, my submission is that, my lord, from the record it is seen, my lord, that notice has been served on R2. R2 is the deputy commissioner. So, my lord, in that view of the matter, my lord, if lordship may be pleased to direct the government advocate.
No, in contempt, we can't direct. She can take notice, but I
That is
can't
the
direct.
difficulty. Otherwise, my lord,
We'll have
because-
to initiate contempt.
yes, he will face the contempt proceedings. Because admittedly, AD card is there, my lord.
No, that's why
It is my duty to point it out, my
I
lord.
have seen that.
My lord. My
I've seen that.
lord.
Uh,
The lordship will kindly then grant us, my lord, 2 weeks time at least, my lord, to file our affidavit on behalf of R1.
Okay. There's no representation from the petitioner or from the respondent number 2 despite service of notice. Full stop. Mr. R. Barpujari, Learned Counsel for respondent number 1. Praise for is granted 2 weeks time to obtain instructions and file affidavit if so advised.
But instructions we have already received.
That's okay. This after 2 weeks.
And so, let's-
Item 15.
Ms. Das, you can only take notice what has happened.
because highest order may follow. Oh, like-
My lord, we have sent for waiting before respondent 3, lordship.
Respondent number 3. Okay, and I'm a on call for the petitioner. Ms. Toshi Senla,
Yes, lordship.
Learned Counsel appearing on behalf of Standing Counsel for Handloom and Textile Department. Submit that the affidavit in opposition has been sent to respondent number 3 for vetting. According to matter since adjourned today, this after 2 weeks.
Lordship.
Just 1 minute.
Madam,
Office note. Office, I'm sorry. From the proceedings of Lahozima Court dated 7/3/2024, it appears that the notice is duly served on respondent number 4. None appears on call for respondent number 4.
Lordship,
Take 2
respondent
weeks.
4. Mr. Tar will be.
Huh?
We have received instruction, lordship, to appear on behalf of respondent 4, AGMC.
Okay. Then you say, Mr. Shinda appearing for all the respondents. Okay. इतना आ गया था। That is very sad.
time being item 2.
I apologize for my conduct, Your Honor. This is regarding my application before the Passport Authority Guwahati, Kamrup. They have denied me a passport for a very long time now. Since 2017, they have kept my applications pending.
Who is appearing for Union of India?
Your Lordship,
Or Mr. D. Barpujari, petitioner in person. Issue notice returnable in 4 weeks. The petitioner in person shall take steps within 2 days for service of notice on the respondents by registered post with AD. Moreover, as advance notice has not been served on the learned DSGI for the respondents, requisite extra copies of the writ petition. We also served on the learned DSGI within 2 days, and acknowledgement thereof shall be filed in court. Next, the notice is made returnable in 4 weeks, list after 4 weeks. Before that, we write the pendency of the petition shall not be a bar for the respondent number 2. To examine the passport application of the petitioner and pass appropriate orders thereon.
Supplementary list, item 16 to 18 for orders.
Well, there in three repetition, only in the item number 16, my lord, there is a application for vacating stay. In other, my lord, there is no application for vacating stay. In fact, my lord, no affidavit and there is no private respondent there to be appeared. So in item number 16, my lord, they filed an application for vacating stay. So your lordship, yesterday your lordship asked me to, my lord, addressing on 226(3), my lord. My lord, whether it is a mandatory or directory, there are two conflicting division bench judgment of our High Court. Two conflicting judgments. And that one of the judgment, my lord, that Honorable Justice Koteshwar Singh and Hokato Shah, my lord, Justice, that has been referred to the full bench. But probably that full bench is yet to be, my lord, constituted, my lord. That judgment, my lord. Two 2022 4 GLT 276, my lord. Listen, listen. Para 103, my lord.
Please give the citation again.
2020 4 GLT 276. That is that judgment says it is, my lord. That is the judgment. That judgment says that it is a mandatory, it is a directory. An earlier judgment, that is judgment by the Justice Navlekar. And now Justice Navlekar and my lord. Yes, Justice Navlekar and Justice P.G. Agarwal. That is
It is directory.
That judgment says directory. And earlier judgment 2003 1 GLT.
2003
1 GLT, page 346. And that judgment, my lord, says it is mandatory. So that's why these two conflicting division based judgment, that's why it was referred to, my lord, larger bench. Your lordship kindly straightway goes to page 100, my lord, para 103 of the 2020 judgment, my lord.
Para
103. May I read it, my lord? Very small para. 103 of the judgment of the 2020, my lord.
yes.
103. We'd also like to observe that since we have taken the view that clause 3 of the article 226(3) is a directory in nature, as opposed to the view of the taken earlier on our High Court referred to the above, we deem it appropriate that the issue may be referred to the larger bench, for which we direct the registry to place this matter before Honorable Chief Justice with a request to constitute a larger bench for decide as whether the provision of clause 2 clause 3 of the article 226 mandatory or directory. So that, my lord, probably from that stage, I do not know, my lord, whether that. So that is the position, my lord. So regarding, my lord, law point, my lord, and my lord, the factual aspect of the matter, my lord, your lordship kindly see. And this petition was moved, my lord, IA was filed on 20/2/2024.
This is that Asian resurfacing case.
Yes, I,
This is Asian resurfacing case.
yes, madam.
You have given this?
Yes.
Okay.
But paragraph 14, 15, 16, 18, and 26 other relevant paragraphs. There. I already decided the
Para 14,
14, 15, 16, 18, 26. It was supposed to be this year, this year, this year. Paragraph 26 is dealing with the discuss about the article 226(3). (32) also, madam.
Constitution.
34, 35, 36.
Okay. Yes, on merit.
Regarding my note that I was filed on 21/2/2024. And it was listed on 6/3/2024. It was listed on 6/3/2024.
Listed on
6/3/2024.
Yes.
On that day, my lord, that the petitioner paid for time to file objection, my lord. That was the first time it was listed, my lord.
And that was listed on my behalf.
Just one. Please don't interrupt.
And on that day, my lord, interim order passed earlier shall extend it and it will be reconsidered on next step fixed. That was the order passed, my lord, and that order was passed in presence of both the parties. There is no objection from the applicant, my lord.
Yes.
So that order, your lordship kindly see order at 6/3/2024.
Yes, we have noted that.
Without any objection, my lord, that was, my lord, an interim order passed earlier shall extend it and would be reconsidered on the next date. The next date is, my lord, 21/3. Your lordship kindly see 21/3/2024. On 21/3/2024, the P. Nayak Learned Council for the BTC submit that affidavit is ready and will be filed within 10 days. I have not taken any time, my lord. Even my lord, petitioner did not any, petitioner did not any object, my lord, and also my lord, applicant did not any object. List this matter on 4/4/2024, on which that must P. Nayok shall bring the record. Interim order passed earlier shall continue till then. So again, that was extended, and there is no, my lord, any objection from the applicant. Then your lordship kindly see on 4/4/24. 4/4/24. That was listed on 4/4/24. The P. Nayok Learned Council for the BTC submit that the affidavit in opposition is being filed today. Mr. A. Ahmed, Learned Council, appearing for the respondent number 8, while Mr. Respondent A. Salam, Learned Council, appearing for the lead petitioner. List the matter on 19/4/2024. Interim order passed earlier shall continue till the next date. So that was also extended in presence of both the parties, my lord. Now, my submission before your lordship, that is also without any objection from the applicant, my lord. So now my submission before your lordship. So when, my lord, the stay order was extended in presence of both the parties without any objection, my lord. Now, my lord, 226, my lord, that 3 will not be, my lord, applicable to the instant case, my lord. Since it is not extended, and then, my lord, it's a different thing, my lord. But in their presence, my lord, when it is no longer a ex parte order, my lord, then. When it is extended, it is not an ex parte order, my lord. It is passed in presence of both the parties. And so far is, my lord, other merit of the concern, my lord. Your lordship kindly see that the application for vacating stay. In fact, my lord, his pen is also not, my lord, defect, free from any defect, my lord. There's a glaring defect, my lord. That was I pointed out. He has not been replied also. Your lordship kindly see, my lord, he's a IA, my lord, 543. IF 543, my lord.
Yes.
IF 543, my lord. That is most important thing that, my lord,
What
his
is this tender
application.
for?
My
What
lord?
is this tender for? Minor minerals,
My lord, yes,
sand.
send, my lord. This is for 7 years, my lord. Now it is, oh yes, for 5 years, my lord. Because it is actually for 7 years, but that pollution environment clearance is only for 5 years. It is extended after 5 years, my lord. Probably that's why it is for presumed to be 5 years. Your lordship kindly see page 27. That is the tender form of the applicant, my lord. Pradeep Kumar Bosimotari. Pradeep Kumar,
This was a tender for, what do you call it? 2021.
yes.
Tender for 2021. Period is from
Period is from, my lord. Settlement period is, yes, settlement period is from, my lord. It is poison number 7 year question. It is for 7 year, my lord. পর্যন্ত মূল্য ছিল। এই পিছনে আছে নাকি আমার পর্যন্ত এই পিছনে আছে এই পিছনে আমার পিছনে Yes, my lord. And in need petition, I have there is a corrigendum, my lord. It is a duration for 7 years, which was by the many years. Page 28 of my need petition, my lord.
It will be from 22 to 29.
My lord. Probably, my lord, from the date of their agreement, my lord. They signed them, but yes, virtually it is from 21 to 29, my lord.
22,
24 to 29, my lord.
24. No,
Oh,
it is
sorry,
22.
21.
No, 21 is the tender.
Yes,
So 22 it will be.
it will be 22, sorry.
22. 29.
So, my lord, your lordship kindly see the IA. In IA, my lord, their tender form is, my lord, page 27. Very first and foremost, my lord, a photo has to be incorporated in the tender form, my lord. But in their tender form, my lord, of the applicant, there is no photograph, my lord. It is a violation of the clause 13 of the NIT, my lord, page 19. Page 27 is the tender form of the my lord applicant.
But this is his copy.
His copy.
Original may have a photograph.
No, my lord, that is the original copy of the photocopy of the original copy, my lord.
In record.
So that will be there. Then another thing, my lord, your lordship kindly see, he annexed his, my lord, solvency certificate. Solvency certificate is the page 17, my lord.
Right.
Page 17, my lord. Page 17, my lord, solvency certificate, my lord. That was issued on 31/1/2022. Your lordship kindly see the date was issued on 31/3, 31/1. But tender was, my lord, open on 27/1, my lord. How it can be, my lord? That solvency certificate, my lord, that is placed on record, my lord. Which was issued later on, my lord, after
Tender was opened on
27/1/2022. Last date of submission is 3/1, my lord. 22. So that's, my lord, and another complaint is that, my lord, that is from the clear from the record, my lord, they have not a, my lord, the court fee of, my lord, rupees 8.25 was not affixed in his tender, my lord. So that is lawful of his tender, my lord. And in respect of me, my lord, what is the allegation, my lord?
yes.
In respect of me, my lord, that is already reflected in the impugn order, my lord, which is passed by your lordship. That, my lord, my labor license is the contractor license, my lord. So labor license, my lord, it was not renewed. Unrenewed license was, my lord, I have produced. But as soon as when it is renewed, I submitted before, my lord, before the, my lord, taking the before the that no before the, my lord, CS was approved. Before CS approved, my lord, I have submitted to the DFO that my renewal license. It is not that I have not given the license. I have unrenewed license was produced, but renewal license was produced later on, but before acceptance of the CS, my lord. And another, my lord, experience certificate is not being annexed by me. That was the allegation, my lord. But experience certificate, your lordship, kindly, if any, that is not mandatory, my lord. The tender form itself said that, my lord, your lordship, kindly see, my lord, tender form and page 107, my lord, of the reply of IA, my lord. Page 107, my lord.
Of the writ petition.
No, my reply to the, my lord, affidavit, miss case, my lord.
Page.
Page 105, my lord. I reply to IA, my lord. Page 105.
Yes, 105.
105, my lord, serial number 5. Previous experience, if any. So that in tender form itself is said, if any. So that is not mandatory, my lord. I have no experience, that's why I'm not annexed, my lord. So that's my submission, my lord. Because my tender, my lord, I am the highest bidder, my lord. My bid is, my lord. My bid is 2.68 lakhs. And his bid is 2.22 lakhs, man.
Two crore.
2.22 lakhs. Bid of the private respond number 8, my lord. Bid of the petitioner is 2.68 lakhs.
Yes.
So that's my submission, my lord, because, my lord, my tender form is, my lord, absolutely all the requirement document I have annexed, my lord, that is clear from the record, my lord. Your lordship, record has to produce, my lord. And in so far is his case, my lord, it is in a open eyes, my lord, your lordship can, my lord, identify because how he can produce the certificate which was issued later on after the opening of the tender, my lord. So that I have, my lord, made an allegation. He has not been denied, my lord.
It is submitted by me, my lord. I am hiding nothing because I found it is correct, my lord. So that is why I enclose it. Repetition, they did not point out that
No,
mistake,
in
my lord.
petition I have annexed.
No, they did not mistake. But I point out that yes, although the petition submitted the letter on, my lord. That certificate petition submitted letter, that is I am annexed here, my lord. That certificate.
In reply, I have stated, my lord, yes.
The represent they disclose it. Even they did not submit their form also. Their form, which documents they furnished, my lord, nothing. In reply, I submitted my applications, tender form, as well as all documents. Now, I stated that yes, or tender was opened on 27. I submitted that document on later on 30. Because I procured it on 30. I applied it, but procured it on 31. That is why I submitted in the office later on. They accept it, my lord. But their main fact is, my lord, whether their license has been renewed on that day, my lord. Not on 2015, their license has been expired. They renewed in 2022, and thereafter they on 19/4/22 they submitted it to the authority. The authority say you come lately. The authority rightly did not consider his applications. And moreover, turnover. So as turnover is concerned, they did not submit any income tax certificate, my lord, turnover also, my lord. They did not submit, my lord. So ultimately, the authority has found that my tender is in order. And because, my lord, his main defect is he has not submitted turnover and as well as license, my lord. These two things is very important. Experience is, my lord, it is not required. But however, I submitted an excellence certificate later on, my lord. I also submitted excellence certificate on 1/2/2000 later on, after 2 or 3 days. I have the excellence certificate. I obtained it and I submitted it for consideration. Your lordship can list my IA, page 18 is a tender. Paragraph 30, clause 13 is the requirement document is to, everyone is to file those documents. Every document I have submitted, my lord, in clause, except expense and solvency certificate at that point of time, along with the tender, but on later on I put it with my lord. And the authority consider it. And that question has not been raised in the writ petition, my lord. They have clarified it after filing my IA. If your lordship kindly see page 20, 20. And the authority, while scrutinizing all the documents, found that their tender has been defective, and my tender has been found operate in order. And accordingly, it is decided to settle the mahal with me, my lord.
Where is the tender? Where is the tender and what are the documents required to be funded?
Yes, paragraph 13, clause 13, my lord. Page 19, your lordship can see my IA, page 19. Page 19, page Annex 5 of my applications.
Page 19, my lord.
Page 19, my
Clause 13.
clause 13. my lord.
Okay, you have the original records?
Please, Your Lordship, Mr. P Naik appears for this matter. He is not available today, but we have got the original records, Your Lordship.
You have the original records?
We have the records.
Nine.
Lordship, we have the records, but I don't have it with me right now, Your Lordship. We have got the records, but Your Lordship, we have it.
At 2 o'clock then?
Lordship, we fix it because he's not there today. We fix the
No,
final
you see,
hearing.
we have fixed it because of the 226(3) operations. Again, an adjournment will lead to
Yes.
another round of argument of 226(3).
Don't have the records, you'll have to get it, Your Lordship, on Monday, Your Lordship.
No. Every day I don't have time. You must understand our difficulties also. We always have a board of more than 50, 70 cases.
Yes.
Every case cannot be rolled over
Yes.
day-to-day basis. Then I'll be taking up only 10
Yes.
matters for next 2 weeks, and other matters will not be listed. There will be resentment in the bar. Even you will feel offended that Lordship is taking up only few matters daily. At 2 o'clock, you have sufficient time. We'll have 2 hours time. Just try to find out because some things must come to an end. My lord. And there's an interim order operating. It doesn't help you. The BTC is suffering. There's an interim order.
Correct.
So that's why.
Correct. The
Question of revenue will come because so far as I am concerned, it hardly matters anything to me. It's very impersonal. I'll just adjourn the matter, extend the interim order, end of the matter.
My lord,
I've told in this court many times that after sitting here for some time, we become heartless, no heart. So just try to get it. If you don't have, then it too, we'll see what can be done. Try to see.
My lord, regarding submission made by my friend for extension, we raised objection. From the first day, we also raised objection. Strong objections I raised.
I don't know. You see, if something.
But ultimately, since the adjournment has been granted, interim order has been accepted. It is there, my lord.
Order of the court is sacrosanct. What transpired on the day, we can't have a presumption.
But
We go by the order sheet.
yes.
The order sheet says no objection, then there is no objection.
No objection is not written, but adjournment guaranteed.
No, that's okay. Many things transpire in court.
But in we
We don't
submission
record
in
everything.
my presence of my friend also, I raised objections, strong objections. Oh, regarding,
That we
but
don't
that was
know.
not recorded. This correct, my lord.
That we don't know.
My lord, already I have completed my part, madam. And to my lord, my journey will be available because I have a doctor appointment today because of my spondylitis, my lord.
You also.
Yes, my lord. So today morning I have my, actually I have a bail, my lord, but it is not feel good to carry it on to the court.
But
my
you're a
lord.
fit person, you.
No, my lord, I don't know, my
Can't
lord.
use
Today I have a physio appointment, my lord. That's why at 2 o'clock I'll not be able, I have already make my submission. I
That's
leave it to your lordship now, everything. So
But
my
take care.
junior will be there, my lord.
Take care, take care.
My lord.
Because these things
And
have suffered.
I'm very grateful to your lordship because of this, my lord, your lordship kindly asked me that you have to address on that point. That's why, my lord, I'm passing all this judgment, my lord. Because I have asked my all the friend that whether what happened to the full mess. So and nobody knows, my lord.
But that issue has been decided recently by the Honorable Supreme Court.
No,
I-
Supreme Court, my lord,
I
that
giving-
226 power is
No, no.
exclusively the High Court, my lord. That's why, my lord, you 226, you also had 226 is
No, in this decision, an observation is made by the
Made.
Supreme Court.
My
No,
lord,
mate,
On to 26.
26.
my lord,
It says that once there is an ex parte, that's why we are searching for that.
my lord.
Asian
Right
Consultancy.
now, I know your lordship will charging more than me, my lord.
It's
But,
okay.
but our High Court position I have placed before your lord.
Okay.
Deputy
We'll try
Officer,
to see if you don't have, then we'll pass orders.
my lord,
Let us see if it can be there.
Deputy Officer.
May I please your lordship, pardon lordship, I missed my item 15 lordship. Lordship, my name may be shown lordship, item 15 lordship. Oblast lordship. M Das lordship. Oblast.
আগতে হলে আগতে মাতি দিল আগতে হলে আগতে মাতি দিল
আপুনি মোৰ মোবাইল নম্বৰটো দি দিলে আপুনি ফ্ৰী থাকিব পাৰিব
শিওর শিওর
মোবাইল নম্বৰটো নহলেও হ'ব ইয়াতে আপুনি
No, not Monday. I have other matters coming up.
Tuesday also, Your Lordship.
We'll take it up on 29th.
29th, right?
But on 226.3, I'll be passing an order. Let me go to the records. I'll pass orders on 226.3.
And my objection may be recorded.
No, no, I'll be disposing of right now. 226.3 will be disposed of right now. Good. I.
We filed
But-
IA and my stance, I meant to mention that is, they have not taken any step for listing the matter. We mentioned it.
Good. Mr. J. Amit, learned counsel for the applicant. Also heard Mr. T.J. Montes, learned senior counsel, assisted by Mr. S. Alam, counsel for the petitioner, for the opposite party number 8. Eight, who is the writ petitioner in the connected writ petition. Forest will be appearing. R.R. Gogoi. Or P.B. Pathak. R.R. Gogoi. Mr. R.R. Gogoi, learned standing counsel for the Forest Department, appearing for respondent number 1 and 2. And Ms.
R.M. Barua, your lordship, R.M. Barua, your lordship,
R.M. Barwa, learned counsel appearing on behalf of
Mr. P. Nayak.
Mr. P. Nayak, standing counsel for BTC, representing opposite party numbers 3 and 4. And Ms. Udas, learned 3, 4, and 6. 3, 4, 6. 3, 4, 6. And Ms. Udas, learned government advocate, appearing for respondent opposite party number 5 and 7. Next one. This interlocutory application has been filed under Article 226(3) within bracket 3 of the Constitution of India, whereby the applicant is the respondent number 8 in the connected writ petition. So you're not respondent number 8, you are
I'm the number 8 in my.
you're respondent number 8 in the connected writ petition. Next one. The learned counsel for the applicant has submitted that this interlocutory application was filed on 22/2/2024. For vacating of the ex parte order obtained by the petitioner in the connected writ petition. So it is submitted that the matter was listed at his instance on 6/3/2024. So accordingly, it is submitted that by operation of the provisions of Article 226 within bracket 3 of the Constitution of India, comma, the interim order, the ex parte interim order passed on 1/6/2023 in the connected WPC 3044 of 2023 stands automatically vacated after 2 weeks of its filing. Full stop. In support of his submissions, comma, reliance is placed on the case of High Court Bar Association, comma, Allahabad versus State of UP and others, comma, criminal appeal number 3589 of 2023, decided by the Supreme Court of four judge bench of the Supreme Court of India on 29/2/2024. Paragraph 34 to 36 thereof is quoted below. It has been separate here. Next paragraph. The learned senior counsel for the opposite party number 8 has submitted that notwithstanding that this interlocutory application was filed on 21/2/2023, not 21, it's 22, 22 to 2020, 24, 22 to 2024. The matter was that this interlocutory application was thereafter listed before the court on 6/3/2024 and on the said date the matter was deferred to be listed on 21/3/2024, allowing the opposite party number 8 to file objection affidavit, and the interim order was extended. Full stop. It is submitted that the matter was thereafter listed before the court on 21/3/2024 and 4/4/2024, but the matter was adjourned on the prayer made by the learned standing counsel for the BTC. Full stop. However, interim order passed earlier in the writ petition was extended. Full stop. Thereafter, the matter was listed on 19/4/2024 And as the senior counsel for the opposite part number 8 was in the midst of parted, midst of hearing of a parted matter. On his period, the matter was deferred and taken up today. And reluctantly, the interim order was extended till today. Post hence comment is submitted that on 6/3/2024, on 21/3/2024, 4/4/2024, and 19/4/2024, when the interim orders were extended, those were orders passed intra-party, INTRA, PART, E. Accordingly, it is submitted that the provision of provision of clause 3 of Article 226 would have no application in the present case as the interim order was extended. Next paragraph. The learned counsel appearing on behalf of the standing counsel for BTC was asked to produce the records, but it was submitted that the standing counsel for the BTC was out of station and the records were available with him, but and therefore it cannot be produced before the court today. So she prays that the matter be taken up on next working day, i.e. 22/4/2024. Next paragraph. Be that as it may, as the learned counsel for the applicant had pressed for vacating of the interim order in light of the provisions of Article 226 within bracket 3 of the Constitution of India, the said there has to be considered, and therefore the matter was heard on the period for vacating the interim order. Next paragraph. From the submissions made by the learned counsel for the applicant and the senior counsel for the opposite party number 8, it is projected that from the documents appended to this interlocutory application, the tender of the applicant also suffers from 3 anomalies, because the documents annexed does not reflect that any photograph of the applicant has been submitted with the tender documents, the solvency certificate relied on by the applicant is issued on 31/1/2022, whereas the tender was opened on 27/1/2022, and accordingly it is submitted that document which is prepared after the opening of tender was taken into consideration by the concerned tendering authority. Full stop. It is also submitted that the court fee of, that the annex documents do not reflect that court fees of rupees 8.25 was affixed to the tender submitted by the applicant. Next paragraph. Insofar as the deficiencies in the tender submitted by the applicant, by the opposite party number 8 is concerned, it is projected that along with the tender document and non-renewed labor license was submitted along with the tender. But before the competitive statement was prepared and got accepted, the renewed labor license was produced before the authorities, which was not considered. Full stop. It is further submitted that the requirement of the tender documents was that documents relating to previous experience be annexed, if any. In this regard, it is explained that the words inverted commas, if any, inverted comma closed, would show that the requirement is not mandatory. And as the petitioner had no experience, he did not annex any document.
Even turnover also not submitted.
Okay. Comma, which also accounts for the non-submission of turnover documents. Full stop. Next, but according to the learned counsel for the applicant, absence of turnover document and renewed labor license was a major defect for which the tender of the applicant was rightly not considered. Full stop. Next paragraph. In light of the nature of dispute raised by both sides, in light of the dispute raised by the learned petitioner, learned counsel for the applicant and the senior counsel for the opposite party number 8, it was required that the original records be inspected to find out the correctness of the allegations and counter allegations. First of how, as the records are not available, the records could not be inspected by the court. Next, under such circumstances, the vacating of the interim order appears to be iniquitous. Iniquitous. INEQUITIOUS. Next paragraph. In the present case in hand, although by operation of the provisions of Article 226 within bracket 3 of the Constitution of India, the interim ex parte order stands vacated by operation of law. No, sorry, operation law we have already stated them, not required the second time. To stop. Nonetheless, we find that the interim orders passed earlier was extended subsequently by this court by order dated 6/3/2023 21/3/2024, sorry, 6/3/2024, 21/3/2024, 4/4/2024. Full stop. It cannot be said that the court, while extending the interim order, had not applied his fine. Full stop. Therefore, comma, it was a constant decision of this court to extend the interim order from time to time. And therefore, as the interim orders were extended in the presence of the learned counsel for all sides, comma, the extension of the interim order cannot be undone, as the interim order was extended on by order dated 6/3/2023, 21/3/2024, sorry, 6/3/2024, 21/3/2024, 4/4/2024, as well as on 19/4/2024. Next bill. The said issue stands answered accordingly. Next para, as the tender records are not available, comma, the matter stands adjourned today. Full stop. Interim order passed at this stands extended to the next date of listing, comma, list on 29/4/2024.
It is on admission column.
Hmm?
Admission column it may be.
Okay.
In my case, I all the parties represent.
This disposes of IA Civil 343 of this disposes of this present interlocutory application. And in the repetition, you will write Mr. T.J. Mahanta, Senior Counsel, along with Mr. S. Alam, Counsel for the petitioner, Ms. S. Barwad and
RM Barua, Your Lordship.
R.M. Barwad and Standing Counsel for the Learned Counsel appearing on behalf of
P. Nayak.
P. Nayak, Standing Counsel for the same thing, huh? Just change the sequence. And Mr. J. Ahmed, the Counsel for Respondent by 8. Ms. U. Das for Government. Same, just Mr. Mahanta will now be first. See that? As all the parties are represented, this is the matter in the admission column on 29/4/2024. Most of the tender records shall be produced on the said date. Next one, in view of order passed today in IA Civil 543 of 2024, the interim order passed earlier stands extended till the next date of listing. Next one, list on 29/4/2024.
Atom may be taken for.
Huh?
Atom is to be taken for.
Oh, no. If I'm there, I'll take the attempt, but I can't say about others. So I'll not
No, it may,
dictate terms to other honorable judges.
it may be part of my lord.
No, absolutely not.
Hello, let's. Yes, sir. Yes, we are observing.
Yes.
আমি আগে নহয় পটককে আহিলে ঠিক আছে বেলেগ কাম নাই কিন্তু আৰ্জেন্ট এটা কাম এই ফাইলটো এই মানুহজনক দি দিলে আধা ঘণ্টা পিছত আহিলে এতিয়া আমি ভাত খাই মই আপোনালোকৰ বেয়াটো নকওঁ দেই আজি আমাৰ কৰ'ণাৰ কাম নাই আপোনাৰ মানে নাই ভিতৰৰ কাম কৰিলে লাষ্ট টাইমে আমার ভাগ্য ভাল যে দুটালে রোগ রোগে হবে ঠিক আছে ভগবান খাবলৈ এটা যে কাম কৰে মেইন খাইটো ভাল মই এটা বাহিৰত